53.
Sorry, I may be hobbling a little bit more than usual. I decided to go for a run on Saturday. That proved to be a big mistake. Yesterday, even though it's not a lot, it's bad. All right, we were finishing up perfection by means other than filing, so we had done some review of automatic, and I believe we had gotten to, tell me if I'm wrong, problem 51, does that sound right? 49? Wow, I missed that by a lot, didn't I?
We got to 50. Oh,
We got to 50?
like we're on, we need to do 50.
We need to do 50? Okay, we finished 49, okay. All right, so. So let's work through problem 50. All right. We have Facade Motors decided to buy an expensive Oriental rug for its main office, and it asked an opportunity to see if they liked it, right? Is it, does the debtor have rights in the collateral? Sufficient for there to be a security interest? Why not?
They have to accept it.
They haven't accepted it yet. So remember, you can't have perfection if you don't have a security interest. Value rights agreement, if the debtor doesn't have rights, there's no security interest, there can't be perfection of a non-existent security interest. Okay. At what point is there, or does the debtor have rights in the collateral in the problem?
When they accept it.
So, how do we know they accepted it? What facts support that conclusion?
Oh yeah, making a down payment.
Sorry?
Making a down payment.
Yeah, they communicated to the seller that they wanted that particular rug, right? Now it's sufficiently identified in the contract. They have rights in it. Security agreement attaches. And the question that it asks then is, Facade Motors did decide to purchase the rug, so it signed a contract to do so. To finance the rest of the installment payments, they borrowed the necessary amount from Night Flyer Savings, giving them a security interest in the rug. Does Night Flyer security interest qualify as the purchase money kind? What's the key question that this is asking us? We have to determine whether this is a purchase money situation. What are the two requirements for purchase money?
Consumer good.
Well, no. Purchase money applies to any collateral.
Oh, okay.
All right? Automatic perfection applies to consumer goods.
Okay.
If you have consumer goods and there's a purchase money security interest in those security, those goods, unless there's some certificate of title, then there's automatic perfection. No filing is required. You're perfected upon attachment. Is this a consumer good?
No.
Okay, but it could still be a purchase money interest. Okay.
Isn't it just money, like lend, to pay for that, and then the money is so used?
Okay. Two requirements. Money is lent to allow the debtor to acquire the collateral, and the money is in fact so used. Is that what happened here? We have a timing problem in this case, don't we? Did the money come before or after? After? Why is that a problem?
Well, because it's really, the money's not being used to purchase the rug. The rug's already been purchased. The money's being used to pay off the old.
There's some obligation to pay for the rug, and that's what the money is covering, but that obligation did not come into existence in order to allow them to acquire the collateral. So the problem, you can have a timing problem with purchase money security interest. The ideal situation is the money is lent before the debtor acquires the collateral and the debtor then takes that money and pays for the collateral, at that point, it's clearly purchase money security interest. What does the next case tell us about timing concerns? Who's in the General Electric Capital Commercial Automotive Finance case, what's the problem? There's a timing problem, right? It's the same as the above problem. The loan that comes into existence, or the money that's lent after the debtor acquires collateral, can't, by definition, can't be used to acquire the collateral. They already have the collateral, right? So therefore, it's not purchase money. In the case, we have an automotive sales situation where the debtor is turning over inventory, which are cars, right? And so how is the timing occurring in that case? Debtor, car sales company, the car dealership, acquires the cars and then sends over the information to the bank, hey, I've acquired these cars, send us money. Is that purchase money as far as that case is concerned? What did the court conclude?
It's done within 10 days, is that what it says?
Yeah, and so what section are we looking at now? That's a filing requirement. If you file within 20 days after it's acquired. Does that change the question of whether or not it's purchase money, though? So I'm looking at 9317E, right? If you look at 9317E, it says, purchase money security interest, except as otherwise provided in 9320 and 321, if a person files a financing statement with respect to purchase money security interest before or within 20 days after the debtor receives delivery, then you have priority over other people. But that doesn't address the issue of, is it a purchase money security interest, which is what the case was about. So the question was, car dealer, as a routine matter, acquires cars, right? I think there's a used car dealer, and they keep buying cars at auction, I think it was, right? And then go to the bank and say, hey, I just bought this car, give us the money. Right? Isn't that the facts of the case?
Yeah, but I was thinking that, sorry, I have this in my notes, I haven't looked over the case in like 10
Weeks.
days. But I think that one of the factors they looked at was the temporal proximity, which they said historically was within 10 days, and then the intention of the parties, right?
Yeah.
Okay.
And this is the issue, right? What is the intent of the party? This is a commercial type transaction that occurs on a regular basis, and was in fact the car dealership relying on the loan from the bank to acquire the collateral? Yeah. So I think that this case is sort of the exception to what I normally would say is, if you have a temporal situation where buyer acquires collateral, then borrows money, not purchase money, ever. This case is a weird example of yes, but. They mixed it all up. The order wasn't perfect, but the intent was there to create purchase money. Yeah.
When does it become more like a letter of credit? Would the bank have to say, like, we authorize you up to this limit?
Well, remember what a letter of credit is. It's a special kind of transaction that it guarantees a payment by a buyer.
Okay.
So you would have that, you would have facts that support a transaction that looks like that.
So
This is not, they didn't do that, right?
So
It wasn't like the auction house was saying, you need a letter of credit in order for us to sell to you. They were selling them the cars, and then they were turning around and immediately going, here's a list of the new inventory to the bank, and the bank saying, here's the money. So they had this contractual relationship where it really was necessary for them to get the loan. The timing was a little off.
Kind of like they were pre-approved.
Yeah, it looks a little bit like that, right? This case is the exception to what I think is the pretty clear rule that you have to have the loan in place before you buy. Most courts would say in most transactions, because most transactions, I think, are single events, So debtor buys something, then asks for money from the bank. One-time event, not purchase money. Here we have an inventory situation where the company is just buying cars on a regular basis and always going to the same bank and always financing it, because that's how they pay for the cars. Court was willing to say intent of the parties to create a purchase money security interest is in this case, exists in this case. Yeah.
So even if, let's assume that it's not purchase money security interest, you can still perfect it in other ways, like by filing, correct?
Well, okay, we have to distinguish between whether or not it's so 9317E allows a creditor in a purchase money situation to file after the loan goes out and have that filing date be retroactive. That's what 9317E is. We will study that again, I promise you, it's a priority battle. But the issue is whether or not it's purchase money is a separate one, okay? Does that help? All right, 51. So what do we have with 51? It'd be nice if I flip to the page. ONB sold promissory notes it was holding in its vault to Last National Bank. Remember that the sale of promissory notes is an Article 9 transaction, so that's a key part of the facts here. It's a sale of the collateral, but we're deeming it to be a secured transaction under 9109. The sale of promissory notes is a secured transaction, even though it's not characterized as one. And what does it say? What does the question ask us? Must Last National file a financing statement or make sure it has possession in order to perfect the security interest under 93094?
I thought possession, as long as it attaches, then it automatically.
If it's automatic, do you need possession?
Well, no.
Okay, automatic is an alternative method of perfection. It says upon attachment, you're automatically perfected. Is this a circumstance where they're automatically perfected upon attachment? 93094? Yes. Possession is fine, and it is a method of perfection. It's not necessary if it's a true sale of a promissory note. Yeah.
So they don't have to file or have possession? This question is kind of missing.
If you have, the benefit of 9309 is that when you have attachment, you're perfected. Okay. No filing necessary. Automatic perfection. Now, what if ONB, instead of selling the notes, used the notes as collateral? So they didn't sell them to somebody else. They said in a list of collateral in a security agreement, we hereby pledge to you our existing outstanding loans. Is that covered by 93094? No, because? Exactly. So understanding the transaction is going to distinguish between those two circumstances. If it's a loan transaction and the promissory notes are collateral, then the regular rules apply. If it's a sale of promissory notes, 9304, automatic perfection. It's an exception to having to take another step. Okay? Yes?
So in this sales scenario, like, it can be automatically perfected when it attaches, but I guess like what I was thinking was like how they would have rights in promissory notes without possession. Is there like a way to do that? If they're given value and there's agreement, can they have rights without?
Well, so
possession?
who is the party that's who is going to be the secured party in this transaction?
The buyer.
Yeah. So the debtor has to have rights in the collateral, and it's a unique circumstance, right? So the transaction would be evidenced by a contract that would list the promissory note as one of the assets sold, one of the promissory notes sold, and that would be enough. Yeah, because they would have rights. Yeah. And I think if you look at comment 4, they talk about in the second paragraph of comment 4, paragraphs 3 and 4, which are new, afford automatic perfection to sales of payment intangibles and promissory notes respectively. They reflect the practice. So it's not because there's some theoretical basis to do this. This is just how the world, the commercial world works, and they just reflect reality. So it's an exception that reflects the reality of how transactions occur. All right. That was 51, right? And then 52, and we're almost done with this. So we have in 52 a Night Flyer loans $20,000 to Portia. Portia moved to enable her to expand her law practice. She gave the finance company a security interest in her accounts receivable. The monies her clients owed to her. One of these accounts has a surety. What's a surety? What's another word for that?
Promise to pay.
Yeah, it is a promise to pay. And what would we call that? If somebody else guarantees your debt? A guarantee. Darn it! Secondary obligor. Yes. Okay, so what does the question ask us?
How to perfect the interest in the surety.
And what's the answer?
Possession?
Well, what are we directed to look at? 9308, right? Perfection of a security interest in collateral also perfects a security interest in the supporting obligation. Essentially, it's automatic. You don't need to take another step to guarantee perfection in the secondary obligation. Automatic perfection is an area, sort of trap you need to just be aware of. In past exams, I have mostly focused on the purchase money security interest in consumer goods when we're talking about automatic perfection. But be aware there are other kinds of automatic perfection, such as the automatic perfection when you sell promissory notes. Okay? But in a typical, so the previous problem 51. So automatic perfection doesn't require any further steps other than a proof that the security interest has attached. So value, rights, and agreement. When those three things happen, the last of those three things to happen, the secured party is perfected automatically. The big one for this class is consumer goods. They purchase money security interest in consumer goods, but there are others, and that's what this section has been talking about. So 9308. So that's that. Okay. Before we move on, I want to make sure. I know this is it gets a little bit complicated, but these examples are sort of the more esoteric versions of this. There's a chance they could question you on this on the bar, but more likely they're going to focus on the main issues in Article 9. All right, filing. Filing is so simple, right? The mechanics of filing. Where do you file? Always. Okay. Unless it's not covered, unless there's some other place that you need to file. So unless there's an exception, you file in the Secretary of State's office. Give me an example of an exception. Anybody? Real estate, right? So if it's a fixture filing, you file with the Registry of Deeds, which is usually a county office, and there's like 3,000 of those. But it makes sense because where do people who finance real estate search for security interests in real estate? In the Registry of Deeds. So any lawyer who's working on a transaction where there's real estate involved, they're going to assume that all interests in real estate are filed in the Registry of Deeds, so therefore it makes sense that a fixture filing is also in the Registry of Deeds. Where's another place that you don't file with the Secretary of State's office? Yeah, vehicles, certificate of title property. I don't own a boat. I know you think, law professor, super rich, has boats and mansions. Does Kentucky have a registry system for boats? Yes? So if you own a boat, you have to register it with the state. So there's a title system for boats. All right? In a state that has a title system for boats, you would have to file with wherever boats registrations are issued, okay? So certificate of title, who issues the certificate of title? DMV, right? Department of Motor Vehicles. So if you're a bank lending on a car, you're going to send notice to the DMV when title gets issued, or when the loan is made, that you have a security interest in the car, whatever their process is, or whatever their paperwork. Okay? So that's when we talk about if you file somewhere else. If it's a patent, where do you file? Probably also the patent office, but you're well advised to file with the Secretary of State, and then also file either in the Copyright Office for copyrights and the Patent and Trademark Office for patents and trademarks. Just to be careful, right? In case you get a court that loses its mind. And you don't know. That's cautious. Okay, so that's where we are. That's it. The rest of the stuff for today is going to be about choice of law. That gets a little harder, and I'm going to talk about that. I'm going to do a lecture on that here. So let's talk about the few problems we have on filing, and then move on to the multi-state transaction stuff. So, problem 53. Hamlet Corporation borrowed $100,000. I read these problems, and I realize law professors think they're so funny, right? Hamlet Corporation, right? Our jobs are pretty dull, so we try to spice stuff up by doing stupid stuff like this. Elsinore Finance Company gave a security interest in corporation's equipment. The parties properly filed a financing statement. When they say it was properly filed, where was it properly filed? Secretary of State's office. Is equipment the kind of collateral that has some other system? No. Generally, equipment doesn't. You file in the Secretary of State's office. Could you possess it? Probably. If it's tangible goods, which it probably is, you could possess it to perfect. But they said they filed, and they properly filed. So exam writing technique. If I say they properly filed, what does that mean? They properly filed. Don't write about it. Okay? Whatever office it was supposed to be in, they got the documents there. And they did it correctly. They didn't make a mistake. So properly filed means in the right office with the right information. Yeah?
Problem is that it's properly filed, it's properly
Oh,
filled out.
I'm sorry. I was just talking. Yeah. Okay. Yeah.
Thank you.
I was just saying in an exam, if I say something like properly filed. Yeah. I got ahead of myself. I apologize. Okay. So what happens? What's the problem in the question?
The clerk indexes it wrong.
Okay.
Properly submitted it. So I think they're good.
Why?
Because in 9516A it says acceptance of the record by the filing office constitutes filing, and 517 says failure of the filing office to index a record correctly does not affect the effectiveness of the filed record.
So they are perfected. Right?
Right.
Security interest is attached, and you tried to properly file. They screwed up. Done. They're properly filed. Does that mean other people can't beat you? Why not?
Are you not protected against other secured parties?
Well, let's read the problem, right? What happens next? 1 year later, another finance company loaned Hamlet Corporation more money, taking a security interest in the same equipment. The second finance company had checked the records and discovered nothing. Since priority of creditors in the situation depends on the order of filing, who wins? Why? Not probably. There's a right answer to this one. 100%, no questions asked, right answer to this.
Because it's not effective against other secured parties.
It's not effective, but it's not just secured parties. Who's it not effective against?
Purchasers.
Purchasers. Where's purchasers defined? Article 1, 1201. Okay? Does purchaser include secured parties? Yes. Because the secured purchaser is somebody who has an interest in collateral that includes security interests, by definition. So would a later secured party be okay against an improperly filed financing statement?
Yes.
Okay. Does that make sense? You okay with that? Let's see if I can. Financing company, the first creditor correctly sends the documents, fills them out correctly, sends them to the office. What does the office do? Screws up, right? The bureaucrats, that's what they do. Are they perfected? 9516, what does 516A say? If you communicate it with the fee, you're perfected. Okay. Does that mean that you beat other people? Not necessarily. Who don't you beat? Purchasers who rely on the system. People who would search. And secured parties are parties that would search. So are buyers.
So if I'm an attorney advising a company, do I have a duty to check the filing after it's been accepted to make sure that it's correct?
Yeah, I mean, you would need to make it clear who's responsible for the filing. Many banks take it upon themselves to do the filing. So you just need to have an understanding with your client who's doing the filing. If you do the filing, then you have the burden. If they do the filing, they have the
To
burden.
verify after it's.
Yes, yes. You're still perfected. So why is that important? Why is it important that you're perfected? Yes. Lien creditors don't search. That's the thinking. The prototypical, the best kind of lien creditor is the bankruptcy trustee, and we want to create a system that we always beat them. We beat them by having a system that says if you send the forms in the right way, you're perfected. If you're perfected before the lien comes into existence, you beat them. Okay? That's why it's like this. But it's not fair to people who use the system to search. So the system says essentially a good faith purchaser, somebody who relies on the system, does a search and doesn't find anything, they should be protected against an improperly indexed document, right? Creditor did everything right, but didn't double check. They're stuck with what the reality is on the system. They didn't double check, it wasn't properly indexed, later purchaser is protected.
I have a question, because it said to look at 9517
Mm-hmm.
and comment 2. So it says, the failure of the filing office to index does not affect the effectiveness. And then the comment says, this section provides that the filing office error in misindexing a record does not render it ineffective in an otherwise effective record.
Yeah, so
This section
are you
imposes-
perfected?
Yeah, it just says imposes the risk of filing office error on those who search the files rather than those who file.
Yeah.
So what's that?
So the idea here is that the record will be wrong and some people may rely on it. But only those people who are purchasers are protected. Does that make sense?
Yeah.
Okay.
I knew that was the case for 516D, I just didn't realize that was the case for 516D.
They want to make sure, yeah. Well, now you say that, I'm sitting here losing my mind.
Yeah, I had the wrong answer too.
I was thinking that if
Yeah,
they
no, I see what
accepted
you're
it-
saying. So-
if they accept it, then
I'm
If they
thinking about rejected.
that's what I was thinking.
Yeah. Sorry, I was thinking improperly rejected. That's my mistake. Sorry. Right? All that is necessary to perfect clerical errors made in the filing office do not destroy the efficacy of a filing properly tendered by the secured party. I was thinking rejection. Sorry, that's my mistake. Getting ahead of myself.
So if they accept it and they screw
Yeah.
it up, then you're protected against.
You're protected, yes.
But then if they.
Because you've done everything that you need.
Yeah.
Yeah,
If
I was
they
thinking
reject it
rejection.
improperly.
Yeah.
Okay. So I reject. Right.
Then there's, if we take a look at, I'm trying to, if we look at 337, we haven't done priority yet. I'm jumping ahead here. No, it's not 337, it's 330. Yes. Yeah. Sorry, I jumped ahead. I was thinking about improperly rejected forms.
Okay.
Right,
Yeah.
yes. So,
So everything's on the purchaser, it's just like strike that basically.
yeah, I was thinking about rejected financing statements, not accepted, but improperly indexed. That was my mistake. Yeah. And that's exactly right, Natalie. The risk of that misindexing is on a later part. Yeah.
So it is effective against other?
It is effective, yes. Sorry, I was, in my mind, I was thinking of rejected filings, not accepted but misindexed. Got jumbled. That's on me, I'm so sorry. Thank you for pointing that out. I had a different fact pattern in my head. Yes, question?
Was there something that I read, I don't remember where I read it, where they said that they have funds where you can sue the filing people to get damages if that happens?
I'm not aware of that, but could be, yes, I mean, the state may send up a
Yeah.
yeah.
The last 2 sentences of the problem.
Yeah. So there are states that take care of it, but I would not rely on that, because like, these things can be billions of dollars. And there's no way they're taking care of a huge number. It's only good for probably small amounts of money, right? Okay, so basically, if you get it to the office, you're done. You need to do what 516A requires of you, okay? If they reject it, you have noticed that they've done something wrong, right? They send it back to you if they improperly reject it. So that's 516D. And if you look at comment 9, comment 2. It's the 3. The third paragraph in comment 3. As against a person who searches the public record and reasonably relies on what the record shows, subsection D imposes upon the filer the risk that a record failed to make its way into the filing system because of the filing officer's wrongful rejection. Okay, and that's what I was focusing on. And then you see the very next comment, compare 9517, under which a misindexed financing statement is fully effective. So that's comment 3, paragraph 3. I feel really bad because I don't want to lead you astray. And everybody here, you should, let's make sure we understand what the outcome of this case is. It's, what I was talking about was if the office sends the document back and they shouldn't have. At that point, you know that they've said it's no good, so you should take further action. With the misindexed, they've accepted it, and you don't know that they put it in the index in the wrong place, so you shouldn't be held to do their job. So Channing, I just wanted, you were making the comment about the obligation to check. You at least know if you don't check, you're okay. But the question always is, if you were asking me a question about whose duty it would be to check, the way we always did at my firm was, if we did the filing, we always verified. If the client did the filing, we left that to them. So that was what I was asking. Yep.
So in both of those situations, they're still perfected, but the difference is when there's like another secured party
Yes.
that comes along? Okay.
If it's rejected and you don't fix the problem, you're stuck with somebody else coming along, right? You may have taken the right steps under 9516A, but the system doesn't have information for people to find. Yeah. Now, I will say, today, the way the search works, that when you type in the name correctly, I think it's very hard for things to get misindexed. Because it's just, they take whatever typed into the form, because it's electronic, and it's put in the system, and then you search electronically, So like, it's like you're searching on your computer, you type in the name of a document, all documents with that name will pop up. So the indexing this is more of an issue when it was a hand-done job, and I don't think misindexing actually happens very often. Pretty hard to imagine. Misindexing not caused by the filer making a mistake. So leaving off a letter, things like that. Okay. We got time. 54. All right. How long is it good for once it's filed?
5 years.
Simple. 5 years. Okay. If they file a continuation statement on May 1st, 2024, is the perfected position continued? Now, they filed originally on May 1st, 2020. So when do they have to file a continuation statement?
6 months before the end.
So when is 6 months before? So when's the first date they can file? November 1st? It's the first day they can file because that's 6 months before, right? After November 1st. Or it would include November 1st. So up to 6 months before. November 1st of what year? They filed in 2020. What's 4.5 years later? 2024, because the anniversary date is May 1st, 2025. That all make sense? Okay. Are they perfected with the continuation statement filed on May 24th? Was it 24th?
May 1st, 2024.
Yeah, problem B. They filed the continuation statement.
May 1st.
Did they file it in the appropriate time span?
No.
Why not?
Too early.
Too early. Okay. Too early is as bad as too late. Are they perfected still? It's good for 5 years. They've made a mistake. Can they correct that mistake? Yes. As long as they file a continuation statement within the 6 months before November 1st to May 1st of November 1st of 2024 to May 1st of 2025. That make sense? They're still perfected up until May 1st, 2025. All right, what's problem C ask? If they never file a continuation statement at all after May 1st, 2025, does nonetheless retain its priority over A and B, who after all always thought of itself as junior. Is that right? Does it nonetheless retain its priority?
No.
The law is very clear about this, right? What does it say happens when it becomes, when it's no longer effective?
It's as if it's been filed.
And this is the concept of, did anybody remember the terminology?
Unperfected.
It becomes unperfected on May 2nd, but what that unperfection is, when it lapses, it's retroactive, right? So let's take a look at 515. Effect of filing continuation statement, let's see. Upon lapse of, sorry, this is 515C, second sentence. Upon lapse, a financing statement ceases to be effective, and any security interest or agricultural lien that was perfected by the financing statement becomes unperfected. So the first thing that happens is it becomes unperfected, unless it's perfected otherwise. If the security interest becomes unperfected upon lapse, it is deemed never to have been perfected, but it's not against everybody. Deemed never to have been perfected as against a purchaser. Who's a purchaser? Well, it's literally somebody who buys it, but it's also,
Secure party.
yes. So the answer to C is, the law states they beat out O and B. A and B wins. We're looking at 515C. Because A and B is a purchaser because they are a secured party. If ONB fails to file continuation in time so that its perfection lapses, but a week later files a financing statement, is it senior to A and B? What's their date of perfection if their prior financing statement has lapsed?
The new filing.
The day of the filing of the second financing statement. Should they file? Yes, because they want to become perfected again. But their financing statement is no good as against A and B. They have lost priority under 515C. Okay? That's pretty, I hope that all feels pretty straightforward. I mean, why is it only retroactively unperfected as against purchasers? Who do we really want to be? The trustee in bankruptcy. It's only retroactively unperfected as against purchasers because we want to keep perfection as against the bankruptcy trustee or any lien holder. Okay? So if the bankruptcy filing happens before lapse, they remain perfected. What happens on the day that it lapses? If there's a bankruptcy filing after that, are they perfected? After, what happens when it lapses? The law says it becomes ineffective, right? You're no longer perfected. If you're no longer perfected and then a lien holder comes along, you're not perfected against them. A later lien holder after unperfection would win. And we will study this again because it's a priority battle and we have a whole chapter on priority. So we're not going to, we're anticipating. But that's the reason for the purchaser. The retroactive unperfection only affects purchasers. It does not affect the trustee in bankruptcy. But once they become unperfected, they are unperfected. And anything that happens afterwards, they have no priority. Okay? I see a quizzical look over here. Draw a timeline. This is when the continuation statement has to be filed, right? So here's the window of opportunity, 6 months. Okay? If they file in this period of time, they're fine. Continues on, right? They file a continuation statement here. What happens? It's lapsed, right? This is no good. It's like it didn't happen. So how does their lapse work? With respect to purchasers, the lapse, so we're going to say lapse, it's as if they were never perfected as against purchasers. Okay? But, sorry. Lapse happened here. Right? They didn't file the financing statement in the 6 months. They're unperfected against everybody else from this point forward. So anything that happens after this date, they have no perfection. But if the lien came into existence before that date, if they're not a purchaser, they're still perfected. That's what they're talking about here. So the retroactive unperfection only applies to people who purchase. And it doesn't matter when they purchase. They still beat them. But if we have a lien that comes in here and the lapse happens here, still perfected. Because the lapse happened after. And the unperfection only goes forward. Okay? It's a preview. We will do this again. Don't worry. All right. E, is an attorney who fails to file a continuation statement guilty of malpractice? To Channing's question, yes. There have been cases where they have found them to be having misfiled. All right, I'm going to go a little bit quickly here because I want to go to the presentation I have for the next material, okay? Before we move on, any questions about this or filing? Okay, so, this is still here. So I'm just going to do 2 short presentations here about the material we read for today. First, we're going to talk about choice of law, and then we're going to talk about what happens when people relocate or collateral relocates. Okay? Out there. Okay. So why is it important? Every state has adopted the UCC. Well, it's identical, right? So we shouldn't have any problems. Except, how many states are there in America? So how many different Secretary of State's offices do we have? 50. So choice of law matters because you got to know which Secretary of State's office to file it. That's why this is important. Debtor is from Indiana, collateral is located in Kentucky, loans made in New York. We have to figure out what law applies. So there's 50 separate, and in fact it's more than 50 because we have the Virgin Islands, we have Guam, they all have the DC, they all have their own offices, right? So the choice of law provision in 9301 is about which office we go to. That's why it's important, okay? Okay. Also, sometimes the states have law that is not uniform. So and I think in the first question we have in here, it's like you can only collect 75%. It's only perfected up to 75% of the payment. Laws like that, we have to know whether they apply or not, okay? So that's why it's important. And then we also have foreign corporations. We have a problem about that as well. Where do you file to perfect a security interest in a in collateral owned by a foreign corporation?
DC.
If they don't have a filing system in their home country, but if they do have a system like ours, then we file there, right? Because mostly it's where the debtor is located determines the law. But for a foreign corporation that doesn't have a filing system in their home country, Washington, D.C. Okay. We do not respect choice of law provisions in the security agreement. 9301 and 302 and 304 through 6 trump prevail over contract choices. So the law of 9301 and all those other sections governs the analysis. It's not what the contract says. So unlike Article 2, sales of goods, you can have a choice of law provision in Article 2 that will be respected by courts. There's no respecting a choice of law provision with respect to where you do filing and priority issues. That's dictated by Article 9. So in Article 9 question, we have to follow the choice of law rules of Article 9. Okay? So let's take a look at the general rules. Mostly the answer is where the debtor is located. And I'm looking, the section numbers are from 9301. Mostly it's where the debtor is located. Huge improvement. 20 years ago, we didn't know where to file. It was a huge mess because sometimes it was the collateral, sometimes it was the debtor's location, and then you had to file at the Secretary of State's office, and in some states you also had to file in the county where the debtor was located. The new rules are simple. Secretary of State's office, where the debtor is located. Okay? Makes it nice and simple. So the rules governing perfection, effective perfection, and priority are dictated by the location of the debtor. So let's talk about the exceptions. So that's the general rule. Let's talk about the exceptions. If perfection is obtained by possession, then we look at the law where the collateral is possessed. Where is the collateral? That law governs when possession is the method of perfection. Who has the collateral when it's been perfected by possession?
Like creditor.
Can the debtor ever possess the collateral for the benefit of the secured party to perfect a security interest? Never. So it is the secured party that has the collateral, or some agent working for the secured party. And we did a little bit of this earlier. But it's never the debtor's location. It's always the location of the collateral, which is held by the secured party. So essentially, think of it this way. If possession is the method of perfection, look at the bank's vault. Where's the vault located? Right? Because that's where the goods are. That help? Yeah.
So, if I had collateral and a bank wanted it, a bank in Indiana wanted it, and I was a resident of Kentucky, but it was held in Illinois, Illinois law would apply.
Well, would they be perfected if it's in Illinois?
Well, if a field warehouse.
Sure.
but in Illinois.
Yes.
So Illinois law would apply. Okay.
9301, subsection 1, right? Subsection 2. The location of the collateral of a possessory security interest dictates the rules about whether you're perfected, the effect of perfection, and priority. And this is right out of the statute, right? And unless I lost my mind, I think I cut and paste exactly more or less restated what it says in 9301. Okay? Collateral is located. Yep. Location of collateral governs perfection by fixture filings. Where do you file for a fixture? Registry of Deeds, right? The county registry of deeds. So, perfection by timber to be cut. And the effect of perfection and priority in tangible and quasi-tangible property. Okay. This last point's a little weird. Okay? Again, we're looking at the statute. Looking at subsection 3. It says, except as otherwise provided in paragraph 4, while tangible, negotiable documents, goods, instruments, money, or tangible chattel paper is located in a jurisdiction, the local law of that jurisdiction governs, subpart C, the effect of perfection or non-perfection, and the priority of non-possessory security interest in the collateral. Sorry, I'm not using this, so we can put this down if it's blocking people's.
It's the.
Oh, it's the screen?
Yes.
275 is better to get extra money. This makes sense because where are you going to litigate about what the rules of priority and effective perfection are? You're mostly probably going to want to litigate where the collateral is located, right? You're going to want to get a sheriff in that jurisdiction to go get it. Or whatever, whatever, you're going to want a court order about the collateral in the jurisdiction where the collateral is located. So the rules about whether or not that possession created perfection should be determined in the state where it's located, where you're going to go get it. Does that make sense? But not whether or not, right? It's not what rules about perfection, right? How you perfect. That's 301.1. It's the effect of perfection and the effect of and priority, okay? Not whether it's perfected, just those last two, okay? So you have a perfection through a filing, but the property's located in a different jurisdiction. You file where the debtor's located, but, so let's say that's Kentucky, but the collateral's located in Illinois. I like that example, right? Whose sheriff are you going to ask to go get it? Yeah, so we should litigate in Illinois, or at least ask what law of Illinois applies, because the property's there. It's their people that are going to have power over it. The state of Kentucky has no power over property located in Illinois. So it makes sense to ask the question, well, do you even have a right to get it? Okay, that's why it's not where you file to perfect property section 1. Now, what does this effectively mean? In all matters with respect to security interests of property where possession is not at issue, it's always where the debtor's located. All determinations. If it's a general intangible, can you possess it? Can it be located somewhere else? No. Right? Subpart 3, read the heading. It only applies to a limited subcategory of property. Goods, things that are tangible. Tangible chattel paper, things you can touch. Money, it does not apply to all collateral. So in essence, if possession and location of the collateral is not at issue, we're just talking about section 1. Non-possessory security interest, it's always going to be Everything is decided by the law of the state where the debtor files. Okay? I don't know if that helps simplify it, but.
Okay, so when you're talking about how to file and how to perfect,
Yes.
it's always the location of the debtor?
Well, now, there are other exceptions, right? It's, right? Usually. For these kinds of pieces of collateral, there's a special rule about how you perfect. Here, you perfect with the DMV. Here, you perfect by control. Same with control here and possession here. Special rules for certain subsets of collateral. Okay? And then agricultural liens. It's where the crops are located. So there are some special rules. But most of the time, for most collateral, it's where the debt is located. So let's do a couple of problems and then, all right. Well, I had a hypo before we do problems. Take a second and read the facts here. Okay? So there's multiple states involved in this problem. That's what. So let's talk about it, okay? Agricultural liens. Where do you perfect? Where the farm products are located. It's just an agricultural lien rule. We've made a choice. Remember, Article 9 applies to agricultural liens, but they're not the classic form of security interest, right? It's they pulled them in and said, we're gonna cover them, but the rules are a little different. And here's an example of where the rules are a little different. Certificate of title, where do we file? Maine, where they're titled, right? Where's the certificate of title? In Maine. And we'll explore, there are some interesting questions about property moving, that's titled, we'll talk about that as well. Okay? I see some quizzical looks. I hope that it's a certificate of title. It's one of those special exceptions, right? You file where the automobiles are titled. Because you have to go on the title. Where do you file for the fixture filings? California, because that's where the real estate's located. And then what do you think the last one is? Where was the company formed? So where is a company located? A company that requires filing with the Secretary of State's office, where is it located?
Place of incorporation.
There we go. Yeah, it's not called incorporation, it's called, organization, I think is the term for an LLC. But that's the same idea. Corporations, LLCs, limited partnerships, they all have some document you file with the Secretary of State. Wherever that person is located, wherever that filing occurred, that's where they're located. Where are most publicly traded corporations incorporated?
Delaware.
So there are tons of filings in Delaware. Even though the corporations are headquartered in other states, you file in Delaware because that's where they're located. Okay? All right, let's take a look at some of the problems. Problem 57. Mary Bush lived in a home she owned in Cheyenne, Wyoming, but she also wanted to buy a large sailboat in Cleveland, Ohio, and planned to keep the boat there, so it's in Ohio, after the purchase for use in her charter fishing business. Okay, is she a consumer or is she a business? First thing, just You know, whenever I see a description like that, I always want to ask, consumer or non-consumer, just because it might purchase money security interest. Ohio secured by a boat. Ohio law provides that whenever a buyer has paid more than 75% of a loan secured by a boat, the creditor's security interest automatically is stripped from the boat. Wyoming has no such rule. If a creditor loans Mary money to buy the sailboat and takes security interest in it, where should the creditor file the financing statement? So right there it says, where should we file a financing statement? What do we know about these states? They don't have title systems for boats. So we're filing. Where do we file? Well, which Secretary of State? We're filing. Where do you file a financing statement with respect to this kind of collateral? What would you call this collateral? It's equipment, right? Is it consumer goods? It's not used for personal, family, or household purposes, so it's equipment. Where do we file and perfect a security interest in equipment owned by the debtor? Sorry? Okay, are you sure about that? Look at 9301. Which part of 9301 governs this? Where do you file? If you don't know, what should you guess? Because that's the general rule, right? Does the general rule apply to this transaction? Is it covered by subsection 2? Is it covered by subsection 3? Is the question of where to file covered by any of the other subsections or any of the other exceptions? Is this perfection by possession? Is the bank perfecting by possessing the sailboat? How are they perfecting? They filed. So where do you file a financing statement? Where the debtor is located. Now, where is the collateral located?
Ohio.
Okay, now, 9301 subsection 3, is it C? What does it say?
The effect of perfection or non-perfection and the priority of a non-possessory security interest in the collateral.
Is determined by the law of?
Located in the jurisdiction.
Okay, so the law of the jurisdiction where the collateral is located, when we're talking about tangible goods, is determined by the state where the collateral is located. Where is it located?
Ohio.
And what is the issue here? A law that strips away a security interest after 75% has been paid. Does that law apply to this transaction? Yes and no. Why no?
Well, I thought we said it didn't.
Oh, well, I said, where do we file? We file in Wyoming, because that's where she's located. Is this tangible goods? Could 9301 subsection 3 apply? It's tangible goods, right? It says that right in the beginning. It says goods. Are sailboats goods? Are they tangible goods? Yes. Okay. Oops. What is subsection? Is it subpart 3? Sorry, C of that? 3? What does it say?
The law of the jurisdiction.
Except as otherwise provided in 4, when goods are located in a jurisdiction, the local law of that jurisdiction governs the effect of perfection or non-perfection and the priority of a non-possessory security interest in the collateral. Is it a possessory security interest? No. But it's located in Ohio, and Ohio has a special rule about security interests that are on sailboats. Does that law apply to this transaction?
Yes.
Yes. It affects perfection and priority, right? Not how you get it, but what happens when you have it. And in Ohio, when the debtor has paid 75% of the loan on a boat, the security interest goes away. That law applies to this transaction because the boat is in Ohio. But we file in Wyoming. So Wyoming would have to respect Ohio law. If they go to collect in Ohio and they say we have a security interest and the debtor has paid 80%, Wyoming would have to say, no, you don't. You're not perfected anymore. All right? I say that a lot. I'm sorry. How you doing? You feeling good about this? What's the general rule?
File where the debtor is.
And the law of that jurisdiction governs. That's the general rule. You have to find an exception to go anywhere else. Normally, we look where the debtor is located. Okay?
But I think I'm confused, but I thought on that slide it was like however, like where it was like one and then however the location of the collateral, right, wouldn't that, so I'm just trying to confuse why Ohio wouldn't govern.
It does.
It does, but we filed.
Not the method of perfection, but the effect of perfection. Right? Perfection goes away in Ohio for loans on boats after 75%. The security interest goes away. That's Ohio law about a piece of collateral located in Ohio.
But we're still filing.
But we're still filing where the debtor is located. Right? This is an exception to this rule. Okay? Right? 4 we don't care about is about mine heads and wellheads and mine heads and things like that. I don't think in my entire life teaching this class, and that's 20 years, I have ever asked a question about a mine head. Okay? So I don't think I'm ever going to ask you about 4. In fact, I'll make that a promise. I'm never going to write a problem where a mine head or a wellhead is involved. That's why I did not include it on this slide. Okay. That'd be a great question, I think, if you were studying in Texas. I think it would matter, right? Okay. Before we move on to the next question, let's just do a quick review. Debtor in New Mexico and collateral in Arizona, where does a creditor file to perfect a purchase money security interest in consumer goods? A lot of mumbling. Why did you go, what is there? This is a trick, right? What's the trick?
It's automatic.
It's automatic. We don't have to file. That's why I always ask, who is the debtor? Sometimes these rules, right? If it's not a consumer, then it can't be consumer goods. If they're a consumer, it can be automatic perfection. That's why I added this in here. There's no filing. We don't care. It's the location of the debtor for everything. There's no filing. We don't care about that. Right? Where do you perfect? You don't perfect it. Okay. Where's the debtor located? I'll spend the last few minutes here talking about this, and then next class I'll start off with a very short slide about what we do when there's a relocation. We'll do the relocation problem. Principal residence for individuals, registered organization, corporations, LLCs, state of incorporation, state of organization, state of filing. Registered organization chartered by the United States. Wherever the U.S. says, but if they don't say, it's D.C. 9307F. If it's the United States, if we're filing against the United States, it's the District of Columbia. Makes sense too, right? What do you do with organizations that don't have a record filed for them? So what kind of organization is a business entity but does not have a document filed to create it? General partnership. Where is a general partnership located? Okay. So if, in a problem, the debtor is described as an organization, but there are no documents filed for it, right? So if I say corporation, you don't have to think about it. It's always the state of incorporation. If I say LLC, you don't have to think about it. It's the state where the LLC is organized. But if I describe this business entity that has people located in multiple jurisdictions and they don't have a document filed to create them, then we go to the chief executive office. And let me tell you, that's not easy to figure out, right? Well, when you say chief executive office, what does that say to you? Who should be there? Yeah. Now, most partnerships don't have CEOs, but they could. It's essentially the nerve center of the operation. Where do most of the decisions get made? That's what we're asking for here. Foreign corporations in a country that has no filing system, right? This is never the United States because all jurisdictions have the UCC, right? And Guam and the United States Virgin Islands. It's the District of Columbia. Can we fit in one more question? Let me see, is it a short one? Peripatetic Corporation was organized under the laws of the state of Delaware, but has its large retail store outlet in New Jersey. Further, the corporation was really a husband and wife type business, and they did all their corporate paperwork at their home in Baltimore. Oh, see, the states start piling up here, right? Their corporate stationery uses their home address. When the corporation borrows money against its accounts receivable, in which state should the financing statement be filed? There's one answer to this question. This is not hard. This is easy. Delaware. They're formed the Delaware Corporation. You file in Delaware. Right? State of incorporation. So problem 58 is simple. Okay? We are out of time. What I will do is I will record the second half of this lecture so you have it before class next time, okay? But I wanted to go over this because for some reason not for some reason, I get it. This is a little bit complicated. I wanted to talk about it in class. I'll record it and we'll also talk about it in class before next class, but please also do the problems for next time. We will not meet on Friday. I'm not even in town. So you can come here and sit and look at the screen, but I will not be here.
Good.
I'm away. Yes.
Is this gonna be posted online?
Yeah, I'll put everything up, but I'll also record a recording of the second half. Yeah, I'll put this on. All right. Professors make mistakes. It is okay to tell a professor they have made a mistake, okay? I'm sorry, I feel really, really bad. I can't tell you how bad I feel about it. It is okay to always question what we say if you think we're wrong. That's what we're here for, okay?